So those who say that they've been fired because of working on investigations into President Trump are lying or misrepresenting?
Well, those matters are alleged in litigation, which is ongoing, so I can't comment on those specifically.
Could you comment on why you fired former acting FBI Director Driscoll?
I can't because it's ongoing litigation.
47 seconds before the question landed, the hearing still looked like every other oversight session that had come before it, a predictable ritual of prepared remarks and cautious answers that lulled even seasoned observers into thinking nothing of consequence would occur. There was no warning in the room, no raised voice, no dramatic pause, no theatrical flourish that signaled what was about to happen. Chris Coons did not lean back or glance around for effect. He simply leaned forward and spoke with the calm certainty of someone who had already walked through every implication of the words he was about to say. He did not use diplomatic language. He did not hide behind procedural framing, and he did not play the Washington game where everyone knows the truth, but pretends not to say it out loud. He looked directly at Kash Patel, leaned into the microphone, and asked the question that had been hanging over the FBI for 11 months. Whether investigations into Donald Trump had been shut down. The change in the room was immediate and unmistakable, the kind of shift that does not require sound to be understood because it registers physically before it registers intellectually. Patel's face changed in a way that seasoned observers of congressional testimony recognize instantly. Not panic, not anger, but the tightening that comes when a witness realizes the script they prepared will no longer apply. His lawyers froze, their pens hovering just above their legal pads, their posture stiffening as if they understood at the same instant that this exchange had crossed into dangerous territory. The entire hearing room moved from routine oversight to something else entirely, something raw and unplanned that nobody present had been prepared to manage. For those watching, it was already clear that this moment would not fade quietly, that it would be replayed and dissected across every major news outlet for days to come. To understand why that question mattered, and why the silence that followed was so heavy, the context of the hearing itself cannot be ignored. This was a standard quarterly oversight session of the Senate Judiciary Committee, scheduled weeks in advance, expected to focus on budget allocations, staffing levels, counterterrorism briefings, and the familiar litany of cybersecurity threats. These hearings are usually procedural by design, safe spaces where senators read prepared statements and agency heads respond with carefully rehearsed non-answers that reveal little and commit to nothing. They are C-SPAN material in the most literal sense, watched mostly by staffers, policy professionals, and the rare citizen with a deep interest in bureaucratic process. That was precisely what this hearing was supposed to be, and precisely what Kash Patel believed it would remain. Patel entered the hearing room at 9:47 in the morning, looking exactly as expected, dressed in a dark suit and red tie, projecting the confident stride of someone comfortable under congressional scrutiny. 3 lawyers flanked him, their presence signaling preparation and control, while 2 senior FBI deputies sat directly behind him, their expressions neutral and almost bored. A thick briefing binder sat open in front of him, tabbed and organized, the visual evidence of a witness who had prepared for every foreseeable line of questioning. He had testified before Congress dozens of times. He knew how to deflect hostile senators, how to run out the clock without answering anything of substance, and how to remain technically compliant while revealing nothing. Everything about his demeanor suggested that he believed this hearing would be no different. Chris Coons sat 4 seats down from the chairman, unremarkable in posture and almost deliberately understated in presence. He is often described as a reasonable centrist, a Democrat who works across the aisle, someone who asks thoughtful questions without theatrics and rarely seeks viral moments. With a background as a former county executive and a Yale-trained constitutional lawyer, Coons is not known for grandstanding or confrontational performances. When he asks a question, it is usually because he already knows the answer and is methodically building a record rather than seeking a headline. That reputation is precisely what made what followed so destabilizing for the room. The first 90 minutes unfolded exactly as anticipated, with senators cycling through familiar topics and Patel responding with practiced ease. Questions about cybersecurity threats from China, Russian disinformation campaigns, and domestic terrorism statistics were met with the standard playbook of cautious affirmations and refusals to comment on ongoing matters. His lawyers barely moved, the deputies behind him looked disengaged, and Patel even checked his watch twice as if mentally tracking the passage of time toward an uneventful conclusion. Nothing in his body language suggested concern, and nothing in the room suggested that the script was about to be torn apart. Then Chris Coons took the microphone. He began calmly, almost conversationally, saying he wanted to talk about something specific, not policy and not budget, but something that had come to his attention. Patel nodded in acknowledgement, his expression neutral, signaling readiness to engage. Coons referenced a date, the 22nd of March, and asked whether Patel had issued a directive to FBI field offices regarding investigations involving former government officials. The room shifted subtly, the kind of shift that experienced observers feel before they can articulate it, as if the air itself had changed density. Patel's expression remained composed, but his hand pressed slightly harder against the table, his knuckles whitening just enough to be noticed. Patel responded with a general statement about the FBI regularly issuing operational guidance, framing it as standard bureau management. Coons immediately clarified that he was not asking about general guidance and produced a single sheet of paper bearing official FBI letterhead. He asked directly whether Patel was familiar with a specific directive dated March 22nd. Patel glanced briefly at his lawyers, a look that lasted less than a second, but communicated volumes to those watching closely. He replied that he would need to review the specific document being referenced. Coons held up the paper so the cameras could see it clearly, explaining that it was an internal FBI memorandum instructing special agents in charge to forward investigation files involving former presidents or their immediate senior staff to headquarters for classification review before proceeding. He set the document down deliberately, allowing the words to settle into the room. Then he asked the question again, plainly and without embellishment, asking whether Patel had issued that directive. The silence that followed was not comfortable or procedural. It was heavy and prolonged, the kind of silence that signals a witness searching for an answer that does not exist. 22 seconds passed before Patel spoke, an eternity in the context of a congressional hearing. When Patel finally responded, he said he was not prepared to discuss specific operational details of internal FBI communications in an open setting. The reaction on Coons's face was immediate and telling, not anger, but the cold certainty of a prosecutor who has just received the admission he needed. He opened a thick folder in front of him, its tabs and markers signaling preparation far beyond a casual inquiry. He explained that since Patel was unwilling to discuss the directive, he would instead walk through what happened after it was issued. With that, the hearing crossed a line from oversight into confrontation. Coons began with the 3rd of April, his voice steady as he described how the FBI Miami field office had been conducting an investigation into financial irregularities involving a Trump Organization subsidiary, an inquiry that had been open since November based on an IRS referral. He stated that the investigation had been active for 5 months, witnesses interviewed, financial records analyzed, and momentum clearly building. Then he looked up and explained that 12 days after the March 22nd directive, that investigation was suspended without explanation. The lead agent was reassigned, the files were boxed and shipped to headquarters, and the case was placed into what was described as classification review. 7 months later, Coons noted, that review was still ongoing with no resolution in sight. Patel shifted in his chair as Coons continued, but he did not interrupt, and the lawyers at his side remained silent. The next example came from Phoenix, where an investigation into potential violations of the Presidential Records Act had been underway following the discovery of documents stored at Mar-a-Lago. According to Coons, the case had reached the stage where witnesses were being interviewed and subpoenas were being prepared. On the 17th of April, less than a month after the directive, the investigation was suspended and its files sent to headquarters. That review, Coons emphasized, remained unresolved months later. By the time Coons referenced the New York field office, the tension in the room had become palpable. He described an investigation into potential campaign finance violations connected to the 2024 Trump campaign, one that had been informed by evidence gathered during an ongoing Manhattan District Attorney case. On the 2nd of May, he said, that investigation, too, was halted and transferred to headquarters for classification review. As he stacked the documents in front of him, each representing a separate field office and a separate inquiry, the visual impact was unmistakable. This was no longer an abstract discussion of process, it was a pattern laid out in paper and dates. Coons did not rush the moment, allowing the weight of the evidence to settle before continuing. He explained that he had 17 such cases, spanning 12 different FBI field offices across the country. Every single one had been active prior to March 22nd, and every single one had been suspended within 30 days of the directive. Every one of them involved Donald Trump or entities directly connected to him, and every one of them remained stalled in classification review at FBI headquarters. The room was silent as Coons finished laying out the scope of the issue, not a cough or shuffle to break the stillness. Patel sat motionless, his deputies behind him leaning forward now, whispering to one another as they realized the magnitude of what was being presented. The lawyers who had been passing notes earlier stopped altogether, their expressions tightening as they watched the exchange unfold. Coons leaned forward again and asked the question a second time, more pointed now and unmistakably direct. He asked whether Patel had issued a directive that effectively shut down active FBI investigations into Donald Trump. Patel attempted to pivot, framing his response around process and procedure. He spoke about the purpose of classification review, describing it as a safeguard designed to prevent inadvertent disclosure of sensitive national security information. He suggested that such reviews were necessary when investigations touched on former senior government officials. But Coons interrupted, his voice rising just enough to signal a shift from inquiry to challenge. He pointed out that Donald Trump had been out of office for 4 years and was now a candidate for president, not an active government official conducting sensitive operations. Patel responded by asserting that former presidents retain certain security clearances and access to sensitive information that require ongoing protection. The explanation sounded rehearsed, but it did not satisfy the concern Coons was raising. Without raising his voice further, Coons reached for another document, thicker than the others and clearly prepared in advance. He explained that his staff had conducted a comparison analysis of FBI investigations involving former senior government officials over the past 20 years. What they found, he said, was a stark departure from historical norms. According to the analysis, the average classification review for investigations involving former officials lasted 14 days. The longest such review on record before Patel's tenure had lasted 41 days. Coons paused deliberately before delivering the comparison that would define the moment. The 17 Trump-related investigations sent to headquarters under Patel's directive had been stalled for between 7 and 11 months. That, Coons said, was not a review. It was a burial. The word hung in the air, heavy and accusatory, and it was clear that it had landed exactly as intended. For months, questions had circulated quietly about why Trump-related investigations appeared to have gone dormant under Patel's leadership. The official explanation had always been the same, that classification reviews and ongoing investigations limited what could be discussed publicly. What Coons had done was pull back that curtain, presenting dates, documents, and comparisons that suggested something far more deliberate. It was not just delay. It was a consistent pattern of suspension without closure. Patel began to sweat under the lights, the physical signs of discomfort now visible even from a distance. His tie had loosened slightly, and his voice grew quieter as he defended the Bureau's integrity. He insisted that the FBI does not make investigative decisions based on political considerations, and that its duty is to follow the facts wherever they lead. The words were familiar, echoing decades of institutional talking points designed to reassure the public. but in the context of the evidence laid out, they rang hollow. Coons interrupted again, pressing the point that none of the investigations had been formally closed. If classification reviews had uncovered legitimate legal or procedural issues, those cases would have been terminated and documented as such. Instead, they remained suspended in limbo, neither active nor closed, frozen without explanation. The only common denominator, Coons emphasized, was Donald Trump. He gathered his documents slowly, as if concluding a case rather than asking a question. Coons then made explicit what had until that moment been implicit. He reminded the room that Patel had been appointed by Trump, had served in his administration, and had publicly stated that he believed the FBI had been weaponized against Trump. Under Patel's leadership, Coons said, every investigation touching Trump had effectively been shut down. That was not coincidence, he argued. It was corruption. The reaction was immediate. Gasps from the gallery, reporters scrambling for their phones, and senators exchanging stunned glances. The chairman banged the gavel, calling for order as the room buzzed with disbelief. Patel attempted to respond, categorically rejecting the allegation and calling it false and offensive to the thousands of FBI employees who serve the country. He framed the accusation as an attack on the Bureau itself rather than on his leadership decisions. But the damage had already been done, the narrative now set in motion. Coons shook his head and spoke again, his tone measured but unyielding. He explained what he saw in plain terms: 17 investigations, a clear pattern, a directive, and months of unexplained delay. He stated that the committee would issue subpoenas for all 17 investigation files. Lead agents who had been reassigned would be interviewed, and members of the classification review boards would be deposed. The truth, he promised, would come out even if Patel refused to provide it voluntarily. The hearing continued on paper after that, but in reality it was already over. After that exchange, the remainder of the hearing unfolded in a strange kind of unreality, as if the formal proceedings were merely a shell continuing out of obligation while the substance had already detonated and scattered across the room. Other senators took their turns, asking questions about border security, counterterrorism funding, and staffing shortfalls, but their words floated past unheard. No one in the audience was taking notes on those answers anymore, and no one watching at home would remember them. Every mind in the room was fixed on the same image: Coons stacking documents, Patel staring forward with no answer that could repair the damage. The hearing had technically continued, but its meaning had already been decided. What made the moment so destabilizing was not merely the accusation itself, but the way it had been constructed step by step, leaving no room for easy dismissal. Coons had not relied on rhetoric alone, nor had he appealed to speculation or partisan framing. He had presented dates, internal memoranda, field office actions, and comparative data drawn from 2 decades of FBI practice. Each element reinforced the others, forming a structure that did not depend on trust in his intentions, but on the internal consistency of the facts themselves. To refute it would require either disproving the documents or explaining the pattern, and Patel had done neither. In Washington, patterns matter more than isolated acts, because patterns imply intent without requiring confession. A single delayed investigation can be explained away as bureaucratic inertia, staffing shortages, or legal complexity. 17 delayed investigations, all involving the same individual, all halted within weeks of a single directive, cross a threshold where coincidence becomes implausible. That was the unspoken logic driving the reaction in the room, and it was why Patel's procedural defenses fell flat. He was speaking the language of process while Coons had framed the issue as one of consequence. For months prior to this hearing, questions about the FBI under Patel's leadership had circulated quietly among legal analysts and former agents. Why had there been no visible movement on Trump-related matters that had once appeared active? Why had field offices gone silent on cases that had previously generated steady leaks and incremental developments? The official answers had always invoked classification, sensitivity, and the need to protect ongoing reviews. What Coons did was show that those explanations, taken together, described not a safeguard, but a system of indefinite suspension. The distinction is crucial, because in law enforcement, delay without resolution can be as powerful as a decision to close a case. A closed investigation generates a paper trail, a rationale, and a finality that invites scrutiny. A suspended investigation generates none of those things, existing in a bureaucratic limbo where accountability is diffuse and responsibility easily denied. By placing the cases into classification review with no defined timeline, the Bureau effectively removed them from the reach of both prosecutors and the public. That was the implication Coons had laid bare without ever needing to say it explicitly. As the hearing adjourned, the reaction outside the room was immediate and chaotic. Reporters crowded the hallway, speaking rapidly into microphones, each trying to summarize the exchange before the next outlet broke the story. Phones buzzed as clips circulated across social media platforms, the key moments replayed and reframed in real time. Cable news producers interrupted scheduled programming, cutting to panels of former prosecutors, intelligence officials, and constitutional scholars. Within minutes, the narrative had escaped the confines of the committee room and taken on a life of its own. Legal analysts began debating whether Patel's actions could constitute obstruction of justice or whether the use of classification review as a delaying mechanism fell into a legal gray area. Some argued that classification authority grants broad discretion, making intent difficult to prove beyond reasonable doubt. Others countered that discretion does not extend to indefinite suspension without documented justification, especially when applied selectively. The phrase Coons had used, burial rather than review, became a refrain repeated across broadcasts and opinion columns. What had begun as a question in a hearing now framed a national debate about institutional integrity. Inside FBI headquarters, though unseen by cameras, the consequences were likely even more immediate. Senior officials would have begun reviewing internal communications, anticipating document requests and subpoenas. Classification review boards, previously operating in relative obscurity, would now find their processes subject to external scrutiny. Agents reassigned from the Trump-related investigations would be contacted, their recollections suddenly relevant and potentially explosive. An apparatus designed to function quietly was being dragged into the open by force of circumstance. The most damaging aspect for Patel was not that Coons accused him of corruption, but that he did so in a way that left Patel unable to mount a convincing rebuttal. Patel denied political bias and framed the accusation as an insult to the Bureau's workforce, a familiar rhetorical move. But he did not explain why 17 reviews had exceeded historical timelines by such dramatic margins. He did not explain why none of the cases had been closed, if legal barriers truly existed. And he did not explain why the directive had been narrowly tailored to investigations involving former presidents and their senior staff. Silence, in that context, functioned as a kind of answer, not a confession, but an absence of explanation that invited interpretation. For viewers, especially those already skeptical of institutional neutrality, that absence spoke louder than any denial could have. Patel's refusal or inability to articulate a coherent defense created a vacuum that critics were eager to fill. Once that vacuum existed, control over the narrative was lost. Coons understood this dynamic well, which is why his closing statements carried such weight. By announcing subpoenas, interviews, and depositions, he signaled that the confrontation would not end with the hearing. He framed the issue not as a partisan dispute, but as a matter of record that would be resolved through testimony and documents. That promise transformed the moment from a single clash into the opening act of a longer process. It also placed Patel under a spotlight that would not dim with the news cycle. For the broader public, the hearing crystallized a concern that had simmered since Patel's appointment. He had been a vocal critic of what he described as the weaponization of the FBI against Trump. Supporters saw his leadership as a corrective, a rebalancing of an agency they believed had overstepped. Critics saw it as an inherent conflict of interest, placing a loyalist in charge of investigations touching his former boss. Coons's presentation gave those critics a concrete framework for their fears. The power of the moment lay in its simplicity. A directive, a timeline, and a set of outcomes that aligned too neatly to dismiss. It did not require viewers to understand the intricacies of classification law or FBI procedure. It required only the recognition that actions repeated consistently produce consequences, intentional or otherwise. That recognition was what made the hearing resonate far beyond the walls of the Senate. As the day wore on, speculation turned toward what would happen next. Would Patel resign under pressure, or would he dig in and fight the accusations? Would the subpoenas uncover internal dissent within the Bureau, or would they reveal a coordinated defense? Would the classification reviews suddenly conclude, their timing itself becoming another data point in the pattern? Each question fed into the next, sustaining the story's momentum. The next hearing, scheduled 72 hours later, loomed over the entire conversation like a countdown clock. Coons had promised to call agents who had been pulled from their cases, men and women whose testimony would carry an authenticity no document could match. If they corroborated his account, the implications would extend far beyond Patel himself. They would raise fundamental questions about the independence of federal law enforcement in a polarized political era. That prospect ensured that the story would not fade quietly. By the end of the day, the image that endured was not of raised voices or procedural chaos. It was of a calm senator asking a direct question, a powerful official unable to answer, and a stack of documents silently bridging the gap between them. That image captured a truth about power and accountability that resonated across ideological lines. It suggested that institutions see themselves most clearly when someone forces them to explain their actions aloud. And on that day, the explanation had not come. As night fell and the initial shock gave way to sustained scrutiny, the significance of what had unfolded became clearer in quieter, more deliberate conversations. This was no longer about a single exchange between a senator and an agency head, but about the fragile boundary between institutional authority and political loyalty. The FBI has long relied on public trust as its most valuable asset, a belief that its decisions are driven by evidence rather than allegiance. Once that belief is shaken, restoring it becomes exponentially more difficult than preserving it in the first place. That reality hung over the aftermath of the hearing like an unspoken verdict. In the days following the testimony, the narrative solidified around the question Coons had posed so simply and so directly. Did the directive issued in March merely formalize an internal safeguard, or did it function as a mechanism to halt investigations that threatened a former president? Supporters of Patel argued that extraordinary cases require extraordinary caution, especially when classified information and national security intersect. Critics countered that caution without transparency becomes indistinguishable from concealment. The line between those interpretations would define the political and legal battles to come. What made the situation particularly volatile was the timing. Donald Trump was not a retired figure fading quietly from public life, but an active political force seeking to return to power. Any action or inaction by the FBI touching his conduct carried immediate political implications. Patel's insistence that the Bureau operates independently clashed with the optics of a directive that appeared to shield one individual from scrutiny. In a hyperpolarized environment, perception itself becomes a form of evidence. Inside the Senate, preparations for the next hearing accelerated with unusual urgency. Staffers compiled timelines, cross-referenced internal communications, and coordinated witness lists with a focus rarely seen outside major investigations. The agents Coons had promised to call were contacted, their willingness to testify gauged carefully. Some expressed frustration at having their work abruptly halted, others remained cautious, aware of the professional risks involved. Each response added texture to a story that was rapidly outgrowing its original frame. For Patel, the days between hearings became a test of endurance as much as strategy. Every public appearance, every statement, every refusal to comment was parsed for signs of concession or defiance. He continued to deny wrongdoing, framing the controversy as a misunderstanding amplified by partisan motives. Yet he offered no new explanation for the prolonged classification reviews, leaving the central question unanswered. That absence continued to fuel speculation, widening the gap between his words and the public's perception. The broader implications extended beyond any single administration or individual. If classification review could be used to suspend investigations indefinitely, the precedent would reverberate across future cases. It would grant enormous discretionary power to those at the top of the law enforcement hierarchy with minimal external oversight. Conversely, if Congress succeeded in piercing that shield through subpoenas and testimony, it would reaffirm a check that many feared had eroded. The stakes in that sense were institutional rather than merely political. As analysts revisited the hearing footage, attention returned again and again to Patel's silence. In legal culture, silence often carries meaning, not as an admission of guilt, but as a strategic choice shaped by risk. By declining to answer directly, Patel avoided statements that could later be contradicted by documents or witnesses. But that caution came at a cost, reinforcing the impression that he could not defend his actions openly. In the court of public opinion, that impression mattered as much as any formal finding. The phrase that echoed most persistently was the one Coons had used at the height of the exchange. Burial rather than review captured the essence of the allegation in a way that statistics and timelines alone could not. It transformed bureaucratic delay into moral indictment, framing inaction as an active choice. Once articulated, the phrase proved difficult to dislodge, shaping headlines and commentary alike. Language, carefully chosen, had done its work. As the 72-hour countdown to the next hearing ticked away, anticipation replaced shock. Viewers who might normally ignore committee proceedings marked their calendars, aware that something consequential might unfold. The promise of agent testimony carried a particular weight, offering voices from within the system, rather than interpretations imposed from outside. If those agents described direct pressure or unexplained reassignment, the narrative would harden further. If they did not, the story might fracture, revealing complexity where certainty had been assumed. Behind the scenes, efforts to manage the fallout intensified. Legal teams prepared for document production, weighing what could be disclosed without compromising genuine national security concerns. Communications strategists debated how to reframe the issue, searching for language that could restore confidence without conceding error. Every decision carried risk, because each action would itself become another data point for critics to analyze. In such moments, even defensive moves can appear incriminating. For the public, the unfolding drama served as a reminder of how power is exercised most effectively when it remains unseen. The machinery of governance often operates in shadows, through memos and procedures that rarely attract attention. It is only when those mechanisms are illuminated that their potential for misuse becomes apparent. Coons's intervention forced that illumination, exposing a corner of the system that prefers obscurity. Whether that exposure would lead to reform or retrenchment remained an open question. As commentators reflected on the hearing, many returned to the understated manner in which it began. There had been no warning, no rhetorical buildup, just a calm voice asking a question that cut through months of ambiguity. That simplicity was its strength, stripping away defenses built on complexity and process. It suggested that accountability often hinges not on elaborate investigations, but on the willingness to ask plainly what others avoid. In that sense, the moment felt both extraordinary and deeply ordinary. By the time the next hearing convened, the narrative was firmly set. 17 investigations, a directive, and months of silence formed the backbone of a story that demanded resolution. Patel would face renewed questioning, now under the shadow of promised subpoenas and potential testimony from within his own agency. The agents, if called, would speak not as politicians but as professionals whose work had been interrupted. Their words could confirm or complicate the picture Coons had drawn. Whatever the outcome, the lesson of that initial exchange would endure. Institutions derive legitimacy not from their authority alone, but from their ability to explain their actions when challenged. When explanation is withheld, suspicion fills the void, often with consequences more damaging than disclosure would have been. On that day, in that hearing room, explanation had been withheld. The cost of that choice was only beginning to be measured.